up next is a returning guest, Representative Cavanagh. Welcome to the show. How are you?
I'm doing very well. Thanks for having me back.
Oh, glad to have you. There's a lot been going on with the. First of all, let me just give it. You're of course first-year representative from the Redford and Dearborn area, and are also on the Judiciary Committee, which has been proposing and discussing and put forth a number of bills to address some of the issues regarding the perceived concerns of the Medical Marijuana Act.
Yes, the perceived concerns.
Right.
It depends on who you're talking to, yes.
Right. That's true. But, that was one of the things that, we had one of your companion members on the committee, Representative Walsh, and he was very, open. We had a good discussion, I think, and he was, the first thing I asked him was, like, what do you see as the problems, and I'd ask you the same thing. What are the real issues that we're trying to stop? I mean, are they identifiable?
Well, I think that there's a lot of misperception. I think that, a lot of press has taken a neutral stance, and they just see that it needs to be clarified. But then you have, certain politicians making it their soapbox issue, which just creates pandemonium. I think that things were pretty good until certain politicians make it their issue, and then suddenly the public is saying, well, what do we have here? My objective, as I've stated before, is to just clarify so that everything isn't a crap roll in the courts. And different jurisdictions interpret things differently. I know some of my colleagues in the House have said, let the courts lead all this out. I don't accept that viewpoint because I'm a legislator, and, I consider it a privilege to serve in the service to define a law.
Well, I like that. One of my things, and I've been talking about this a lot, and I wonder what a legislature's view is of this. There's a very clear statement in the referendum, the language of, a patient, registered or unregistered patient or caregiver shall have a defense to any charges involving, marijuana. And I can tell you as a lawyer for the first time ever, there's clients that I have, and there's rulings that are made by judges that are ordering or granting the prosecutor's motion, precluding me from mentioning the medical marijuana card, to the extent where, the honest truth is not being stated. And it's just bizarre. I mean, we had Barb Agro on, who's a 70-year-old, grandmother. She was just celebrating her other, and, she didn't have her door locked when the police came in, and that was a, not locked and closed facility, and she was barred from being able to mention medical marijuana as a defense. And the jury sent out 3 times questions to the judge: is she a medical marijuana patient or not? The judge would not, give an answer. I mean, so in the court system, to me, this has been the main reason why things are the way that they are, because there's no jury that's checking the behavior of law enforcement, in terms of the interpretation. Is the legislature contemplating something to guarantee this right to the patients and caregivers?
I think I've said before that I am really trying to make this a public health issue versus a public safety issue. And, there's legislation that we're talking about. There is a set of bills of 8 bills. I'm trying to define the doctor-patient and a bona fide relationship. It's not as easy as I thought it would be.
Let me ask you this. That's a good place to kind of, because I'm aware of what the bills are, and just recently, last week, there was that memorandum that was put out by Lara, which it's obviously came from the Medical Licensing Board of Michigan, and their input as far as the definition of a recommendation or a direction of how physicians that wanted to participate in certifying medical marijuana patients should go about it. And I know one of the bills that was pending was 4851, which was to define, legislatively or amend the act to change that definition. Is that needed now with this new memo?
I haven't done the analysis, and that will be a topic of conversation. Next week, Representative Horn, Walsh, and I are going to get together and see which bills are not needed, which will be run through committee the following week. I expect Judiciary Committee to take these up 2 weeks from now. And what I was going to say was there's an original package of 8 that I only expect maybe 4 to go through, and the other 4 we'll find out aren't needed or antiquated or, just shelved. But it's also through conversations, through testimony that I've heard over the last, not testimony, just people talking to me over the last 6 months. It's really opened up that there's far more things we could do. I was very disturbed when, the Court of Appeals said that distributor...
patient to patient.
Isn't right, and how it's brought out. No one grows exactly what they need, and what do you do with the excess? And I think that we should define that versus, everybody having no clue and saying you got to flush it or burn it.
Well, let me ask you something. This is an interesting point of things because there's always this issue with the existing law as to what extent can patients acquire their medicine? Are they allowed to transfer to another patient or get it from another patient? Court of Appeals said no if there's money involved. And then there's this other issue of whether a caregiver can provide cannabis to patients outside of the 5 that they're connected to, connected to through the registry where their name's on the back of the card. Do you read the law in a more expansive way that would allow patients to acquire from a caregiver that they're not connected to, or a caregiver to provide to somebody who's not, one of their 5? Do you read the law in that way, or more in a limited?
I would like to see that. No, I think it's open to interpretation the way it is now. I'd like to figure out some way of distribution that's fair to everybody, and at least, set some guidelines for law enforcement, because they right now don't have much clarity, and different jurisdictions treat it differently.
Yeah, but we've talked about this before. I mean, we've agreed that one of the major issues is that there's nothing put into the, training. And I don't mean physical training, but just the 80 years of one way of thinking about cannabis, and such a negative way. And we're 3-4 years into it, and there's been some evolution. But you can't, how much can you expect with what's been offered? And especially with the message that the leading law enforcement agent has had in terms of, the attitude towards it. I mean, not much of that is not focused around protections and, limiting arrests.
And that's where I feel my role is. I mean, to educate, to actually create some laws that make it fair and also make it a public health issue versus a public safety issue.
Well, then wouldn't it be fair then that the doctor bill, I mean, we know that if there's a law that's passed or change in a definition, that law is going to be enforced by law enforcement. They're going to find, they're going to see the new law, and it's going to be another way for them to find a technical, if a doctor's not, they didn't have a pre-existing relationship, they're going to arrest a doctor, they're going to arrest a patient who went to that doctor because, they didn't have that, whatever. That's a public, that becomes public safety, as opposed to Lara, we would agree, would be something, from within the public health community.
No, I missed the show. Are you saying that John Walsh was on earlier?
No.
He was on last
week.
Last week.
Yeah.
Yes.
Okay. And
he hadn't heard about it. It had just come out, but
But and by the same token, I don't necessarily want to opine because I very much, if Laura clarifies those things, and the Republicans, especially our Attorney General, is fine with it, then I'm good. But that's why I was going to sort of feel this out with Chairman Walsh and Representative Horn.
Why does it matter what the Attorney General thinks at this point? Doesn't everyone? I mean, didn't we kind of? Hasn't much of the discussion been about providing more accurate information to the legislatures? Hasn't that kind of been the reason why things have kind of leveled off a little bit from the 15 or 16 bills that it started with?
Yes.
Okay, so why I mean, you just happen to mention that, it depends what the Attorney General wants. I mean, that just strikes me as an odd statement. Can you?
Because he's driving a lot of these conservative votes, and so he has some influence and some push on all this. Not necessarily in my caucus, but in the majority caucus. So
Sir,
I don't necessarily say we have to appease him. But if we just lay down and leave the questions open, then he's going to precipitate with his viewpoint.
Sir, could I ask a question, please?
Please.
One thing that really concerns us, and you have to understand it from our perspective, being the victims here, is
Yes.
the rhetoric that has been hurled by Schuette at our sick people. People that are really, in a lot of cases, unable to care for themselves. They have cancer and other diseases. And a lot of these bills, if you look at the net effect, would land these people in harm's way, put them in jail, put them under Schuette's thumb, more or less. And you have to understand our concern there is any bill which makes it easier for a sick person to be arrested causes us a lot of concern, because right now, even without the law on their side, they're throwing people in jail. So, our concern, and I guess my question is this: can these bills be structured in such a way that patients aren't penalized, that their rights aren't sacrificed to appease Bill Schuette? That's our concern.
That's my goal. I by no means am driven by his rhetoric. And I feel my role is the advocacy of the patient, and try to do some compromise that's going to subdue a lot of these actions and clarify the law at the same time.
We want to help you.
It seems to me that there's a timing associated with the Laura memo. The backing 2-page addendum was from the Board of Medicine, and it was actually issued and published back in August. And it seems curious that it's just with this new legislative pressure from your bill, HB 4851, that it seems that they may have picked up the issue and decided to deal with it correctly. Do you feel that there's any way that the legislature can help to pressure Laura in other additional areas? I know that we had discussed the card issuance, and last show you said you were going to take that issue to the governor, and I was going to ask you sort of how that had gone, if that had gone, and also if you feel that you could have effect in pressure against Laura to get them to implement the law rather than changing the law itself.
Representative Horn, Representative Walsh, and myself are all on the same page for precisely that. We believe that that we could assert legislative pressure on the administration to make some of these changes, and it won't take bills to do it.
That's great.
I'm not certain of anything, but that we are all on the same page that things need to be more timely. I look at expanding the time period to, I propose 3 years. I think we might settle at 2 years versus an annual renewal. And whatever else we can do.